Welcome back. Now let's get the show really started. On Wednesday, the Supreme Court gave its judgment on the 2019 presidential election. The Supreme Court dismissed the appeal by the People's Democratic Party, PDP, and its presidential candidate, Atiku Abubakar, challenging the victory of President Muhammadu Buhari in the presidential election of February 2019. The PDP is asking the Apex Court to release their reasons for the judgment on the presidential election petition filed by the party and its presidential candidate, Atiku Abubakar. Well, we have two lawyers who are going to look at this with us this morning. We have in Lagos, Mr. Joe Mokedi. Good morning.
Good morning. My pleasure.
And joining us from Abuja, it's my pleasure to welcome Mr. Kayode Ajulo.
He's not there yet. He'll join us in a bit.
Okay. All right then. Well, we have Mr. Mokedi with us in Lagos, so let's get on with it. We've heard all kinds of comments about this judgment. But first of all, let's begin with what are your thoughts about it before we look at other comments that have been made about this judgment?
For me, it's the Supreme Court, it's the apex court of the land.
So it is the end.
And it's the end. So that's just the real thing there. Whatever they say, however you review it, however you feel good or bad about it, is the final. Although they say they may not be infallible, but they are final. That's why they are. You know. So that's just the issue. So when we expected a kind of robust judicial review, judicial pronouncement, judicial kind of review of what transpired. Nigerians, we are looking up to the Supreme Court to analytically assess the decision of the tribunal, the panel that handled the matter, and they come up with more intellectual kind of input into what transpired at the lower court, at the appeal, at the tribunal that handled the matter. But they took everybody by surprise. By coming up with something that people considered, to some extent, with due respect to them, has been lazy, been like a kind of not well thought out, not premeditated, and I know Nigerians were like thrown aback. We were like, this is not what we actually expected. We expected issues to be looked into, analyzed, give reasons, even if you are going to, like, at the end of the day, still give ruling in favor of the president. But there would have been a greater intellectual depth, discourse on this issue that will enable Nigerians to see more, reasons why the presidential candidate of the PDP lost that election. Okay. But the Supreme Court just came up to read a kind of few paragraph statements and then said reasons to be given later. From its intellectual laziness. I'm so sorry I'm using this on the apex court of the land, where I also invariably belong to. But then, that was the reaction. That was also my reaction. I expected to develop my intellectual faculty from the pronouncement of the Supreme Court and also enlarge the scope of our jurisprudence and the election. But that wasn't what we got.
Okay, we've since been joined by Mr. Kayode Ajulo. Mr. Kayode Ajulo, good morning, and thank you for joining us this morning. If you can hear me, Mr. Ajulo, what are your thoughts about the judgment of the Supreme Court on this matter?
Well, let me start by saying one really need to thank the Supreme Court for doing the needful. And like I said, with what everybody has been asking me, this is in any election, particularly when you have issue in court. Some may lose and some may win. But what the Supreme Court has done is it's within the ambit of law. Like my friend there mentioned that the Supreme Court should be a very grand, a detailed judgment. But we have to understand one thing. Our law, part of our law is convention and practice. And it has been the practice of the Supreme Court from time immemorial. If you remember when the case of Yaradua and the other matter, Supreme Court can easily say, this is the position. We are going to give the reason at the later date. because that is what they're going to do. But because of the tension, because of the way it is expected that the Supreme Court just quickly, we need to deal with these issues, and this is our position, and the verdict has been given, and there's nothing wrong in saying we are going to give the reason for such verdict later, which has been the practice for long. This is not the first time. I'm sure as a lawyer that practices in the Supreme Court, he must have seen that before. He must have heard that before. But coming to the public and trying to castigate Supreme Court for doing what they have been doing for quite a lot of time, I think that should be, that's what's on loyally. We must be sincere with ourselves.
Yeah, Mr. Ajilo, Mr. Mwabweze, in his comment, said that the judgment said, and I quote, "We have examined all the briefs of argument and the exhibits for over 2 weeks, and we have all agreed that there is no merit in this appeal. The appeal is hereby dismissed. Reasons to be given on a date to be announced." His comment after that quote implies that the whole thing was determined even before they came to court on the day that they made that pronouncement. Would his thoughts be reading meaning into where there is no such meaning?
Well, I wouldn't like to retreat the position of the learned Sikh, that's Professor Nwabweze. I am in court. I know what happened in court, and it will sound very funny to now try to toe the line of any other person. What the Supreme Court has said is it's so clear that in our practice, you have to file your case. The court has to look at it. Even sometimes, courts always seem to have really seem to have seen what you are about. That is why you know that you have a certain date in which you can file all your argument, and it is expected of any judge that what is sought to have gone through the argument even before coming to the court to even make any decision. And I believe that is why, and mind you, this one as mentioned by Nwabweze, you notice that the court allegedly said that after listening to those arguments. And I believe the court is still right in saying that we have gone through the whole thing. In our own considered opinion, this argument lacks merit, and they so dismiss it. It is within the ambit. Is it within
Mr. Ajilo,
this is the power of the Supreme Court to make.
Permit me to interrupt you at this point in time. We need to go on a quick break. When we'll come back, we'll continue this conversation. Please stay with us. Thank you for staying with us. We're still discussing the fallout of that final judgment on the Presidential Elections Petition Tribunal, and which went up to the Supreme Court, and that final verdict. Okay, so Mr. Mukedi, you heard Mr. Ajilo talk about what the legal system, the legal jurisprudence, as you put it here, has been, what the trend has been as regards the judgment of the Supreme Court to certain things. But you don't seem to agree, because I saw you shaking your head. For me, there is no rules that said it must, judgments must be preserved, more judgment must be read, and then reasons for reason for that judgment to be pronounced later. That's the practice of the Supreme Court. But it's not in all cases. It's not in all cases. It's not like there is a rubber stamp rule that said it must be like that. This is something they do by discretion. There's what we call discretion in courts, which is like powers, exercised by the judges on their own. But then, what we're saying is that in a matter like this, looking at the tensions, looking at the issues that arose from the appeal, from the tribunal, that we expected the Supreme Court to have given the reason for that judgment, to have done a detailed job on this issue, so as to enrich our jurisprudence, so as to look at the merits of the appeal, because there are so many issues in the appeal that people thought the Supreme Court would have given further explanations to, like the issue of these affidavit certificates and all these things. Now, court of the first instance might just make a pronouncement on the issue. Appellate court, but people will look at the higher court, the appellate court, to analyze that issue, give reasons why that ought to be or why that ought not to be, so as to clear the gray areas in law, and then also elaborate on what the law says. That's when we are reading Supreme Court decisions in our law reports. It's an intellectual discourse. You learn a lot. Maybe at the appellate level, you might have confined yourself to a certain kind of opinion, a kind of thought, a kind of legal argument. By the time you see Supreme Court judgment, Supreme Court rulings on that issue, it will widen the scope of your horizon in terms of what the law says, and also make you to review certain decisions or pronouncements of the lower court. If they're going to uphold decisions of the lower court, they will further elaborate on why they're upholding it. If they're going to rule against it, they will also elaborate on why they are ruling against it. So when you read your law reports and see Supreme Court decisions, it will be something that will at the end of the day, you know that justice has not just judgment, but justice has been has been done. So in this present case, we are they have done that before reasons to be given later. But is that a good practice? Is that what must be the practice? Has that been the way they do it in all the cases, in all the matters? This is an election petition. It has to do with our electoral system, it has to do with our electoral laws, it has to do with our conduct of our election, it has to do with INEC, it has to do with time of election, qualifications for elections. And this is election period, and this is democracy. So now that the first judgment generated a kind of serious issues, we expected you to tell us this, so that the appellants, I mean the people that went on appeal, the PDP, will not know why they have lost.
But there are those who feel that it was just a waste of a court time. I mean, going through all of that appeal again.
No, in law, I mean, when somebody has raised an issue on appeal, when there is issue in his brief of arguments, when issues have been raised, those issues might have not warranted the court to look at them. But when people, the counsel that actually appeared in the lower court, decided to go on appeal, it's left for the appellate court to look at the issues, canvassed. So, but they cannot tell them it's a waste of time. If on their own they have formulated issues, that the fallout of that decision at the lower court, that look, we believe that so and so issues were raised, we are not properly dispensed at the lower court. They have the right to go to appellate court.
Okay.
You can't just say on your own knowledge, on your own intellectual kind of understanding, they don't have right of appeal. It's waste of time. They have that right under the law. They have that right under our rules to appeal. Appeal is as of right. Where appeal is as of right to appeal.
Okay.
So that matter now, they have the right to appeal, and they have raised issues from the pronouncements and judgments of the tribunal that look, there are issues here that we are not comfortable with the way that we are decided at the tribunal. Therefore, we are heading to Supreme Court, and they cannot tell them not to do that.
Mr. Ajulo, in a system like ours where there are a lot of gray areas, you hear, especially you lawyers, talk about the fact that the Constitution is not exactly, is not exact, is not decisive on this matter, or decisive on that matter. Many times you end up looking at judgments of the Supreme Court to decide on certain things or to explain certain actions and help make decisions easier. So when you have that kind of situation like ours, and then you have a system where the Supreme Court will give a judgment and say reasons for the judgment will be given later, like what Mr. Wokedi said, wouldn't that be pushing the matter further away instead of dealing with it as at that point in time?
Well, I don't want to believe that is the situation and it's not about pushing the matter away. First, let me start with this. I remember that Mr. Wokedi opening speech talked about the infallibility or fallibility of the Supreme Court. The truth of the matter is that Supreme Court is even a law, is a rule on itself. And that's why you see that most of their rules, they can easily make any rule and whatsoever it is. And that is why we say, after that, the only way you can take your issue to is the God Almighty. Now, secondly, I've tried as much as possible to check if Mr. Wokedi happened to be one of the counsel in that court or whether he was in even the court, then we'll have understand where we are talking about. This is not the first time. This is not the second time. Supreme Court, because of some exigency of issue, mind you, this issue of presidential election petition has generated a lot of tension, generated a lot of issue controversy that I believe that any right-thinking institution would believe, let's put everything to rest. And the best way is to say And like I said, this is not the first time they've been doing it. Most of the presidential election, this is always the way to say, look, this is the position. We are going to give our decision later. And mind you, if you notice what I've been discussing, I'm even here to go to the merit of the issue, because as it is now, it is not the right time to do that until we see the reasons of how the Supreme Court arrived at saying this thing lacks merit. But on a more serious note, by the time you look at the petition itself, you wonder, you ask yourself, why must this thing be brought before the court? Why must we even disturb ourselves? This is the petition that was prepared with you mind that it's more of of emotion, more than law, more than reason, more than what we as a lawyer are supposed to do. It is more that those that prepare, they are so annoyed. Yes, I'm here to know who they are annoyed with, to prepare that, and such kind of processes is supposed to be dumped at the judicial dustbin, and that is what the Supreme Court has done. Yet, because they will say later we are going to give our reason. Who knows? It may be able tomorrow. With time, because most of us, we are waiting for this reason because we'll be part of the law report. These are the things that will be cited. But to castigate what we're here to see, what we're here to know what it is. But the practice, I'm here to see anybody to fall that. Even I'm sure Mr. Nwokedi or Professor Nwabueze, who never only appear in court just once and started making some aspersion on the judiciary or on the Supreme Court, saying what it is. I think it is better we need to set aside these politics. If we are lawyers, then we discuss as lawyer. Then if we are politicians, we discuss as politician. And these are the things that I'm most of the time picky with, that we need to really face it and face reality. That process, that election petition, even if not, that we thank God for democracy, we thank for rule of law. In some climb, no judge will even touch it to say right from the beginning. Even it will be stopped at the point of clerks, registrar trying to record it and trying to put the record of the court to say, look, this is not the kind of thing that should be brought before the court. We don't need this. But this is Nigeria. We all talked about rule of law. We all talked of democracy. Whatsoever you have, it must be deliberated upon. And I believe that is why our courts picked that petition. And at the end of the day, assign the right position to that petition by dumping it in the dustbin, and that is the way it should be. So we need not lose our head and waste our time about it until when the reason comes out. Then we can now really discuss in detail what transpired and the reason why the Supreme Court choose to throw the petition over the window.
Now, Mr. Ajulo, is it normal practice for the Supreme Court to decide on a particular matter and then to give the reasons for their decision later?
That is what I've been saying. That has been practiced for a very long time. I'm sure Mr. Nwokedi will agree. We not even flaw that. Supreme Court have been doing that for long, even in many places. That's why I asked, if you are a practicing lawyer, if you have been going to Supreme Court, you see they've been doing that for several times. They can easily say, oh, this is not what it is, and then say it. This is not the first time. Let's even assume that this is the first time. The question we should ask is that, can we say the Supreme Court has jurisdiction to do so? We say yes, because like what Mr. Nwokedi said, they may be at fault, but we can't question it. But on this issue, particularly to your question, this has been on for quite a lot of time, except the only lawyer that may come to oppose that is maybe those who may not know what has been the practice for so long.
Okay, Mr. Nwokedi, is it normal? A lawyer's question. Is it normal?
There are so many, like my learned colleague has said, Supreme Courts, in most cases, review even their decisions. There are so many cases that Supreme Court might decide upon, and after years, they will also review it, and then rule against even what they ruled for before. We have a plethora of cases of such nature in our law reports. So they are not infallible. That they are doing something, I'm sorry, my learned colleague there is just because we are lawyers, and we feel that Supreme Court is like the embodiment of judicial process and a kind of the ego of legal profession. You dare not say anything contrary to what they have done. But that doesn't mean the Supreme Court decisions or opinions are not reviewed. We are lawyers, and we review, we make our opinions known. We speak out. We say certain things that might also help them. And then if we look at certain issues done by Supreme, they are human beings. They are humans. They were also lawyers like us before they were appointed. They grew in ranks from the bench to get to that place. But they didn't fall from heaven. They are lawyers like us. They were all humans too before they were appointed. So what we're saying, and we are developing the law. And we discover a practice that might not serve the purpose of the law at the moment, or that have been like a practice that might not be what might serve the interest of the law. We might just make our opinions known with respect to that. That doesn't amount to castigating them. That doesn't amount to calling them names. What we are saying that the way this petition came up and the issue generated in this election, that we thought that they would have done that at the moment, so as to guide the public, so as to let people know the reason behind the decisions they have given. That giving a ruling now and saying that decisions will be given later it's not completely normal. It's not completely normal. It may be the practice, but it's not completely normal. People want to know the reason behind certain things done today, so they will go home and know this matter has been settled and settled for all. Not tomorrow, this issue, they will not give reasons, and then the issue will reoccur again. What I'm saying is that do it at the same time, because we are trying to make our judiciary to become efficient, to become effective, and to become timely. Unnecessary waste of time and all these things, they are also, casting a negative image on the judiciary. So the issue he raised, Supreme Court they're not perfect. They overrule their decisions with time. There are issues that we know that Supreme Court had this decision binding as a precedent in court, that within about 2, 3, 4, 5 years, they will rule against that same decision, showing that a certain practice or a certain precedent or a certain rule might not always be in practice forever. So we are saying this issue of ruling now and then giving reasons later might not be the best.
But Mr. Nwokedi, it makes no difference, doesn't it? If they give the reasons later and you have somebody has an objection, it doesn't amount to anything because they have reached the Supreme Court and they've reached the final, that's the end of the journey.
I said they are final.
So it doesn't really matter, does it?
Not because they're infallible, but they're infallible because they're final. They say they're final, not because they're infallible, but they're infallible because they're final. That's a popular saying. But the Supreme Court, they say they're final, not because they're infallible, but they're infallible because they're final. That any appeal for Supreme Court will be taken to God. So we take it that they're final, not because they're infallible, but whatever they give us, we'll take it. And it becomes binding until a new decision comes up to review or to invalidate that. So
what can cause that to happen? For what reason may this be reviewed? So that the Supreme Court will now have the opportunity to reverse itself if the need be.
It might be like there might be issues that the previous decision might not cover. The Supreme Court is an institution. It's made up of judges. The judges that gave that judgment might no longer be there. We remember the days of Kayode, issue. We remember the days of Putad, days of former, so many of them there at the Supreme Court. They're no longer there. So some of them have been like there before. They might have a reason, prevailing circumstances at that point that made them to toe that part in delivering that judgment or giving that opinion. But later on, the other people that might be there might also look at what was given and vis-a-vis the prevailing circumstances in the society and other issues, the new elements that might come in, and they review it. And then the former decision might no longer be binding. The decision might be so harsh that people might have suffered so many kind of defects, so many kind of legal injury as a result of that decision. And they might look at it again from their own intellectual point of view, and then review it, and then come up with a new decision that will nullify the earlier decision of the Supreme Court. And that new decision will become binding. My learned colleague, they knew about this. So the Supreme Court is not as if whatever they have been doing as a practice must remain the practice. Or whatever decision they give remains the decision till eternity. It doesn't work that way. After years, they review some. And the issue of going on the merits of appeal, like canvassed by my learned colleague, you are not going. When somebody has a cause of action, when somebody believes that his right has been trampled upon, there was a breach, maybe in transactional issues, there was a breach, maybe in his kind of corporate issues, he has the right to seek redress in the courts. That's his provisional constitutional right. You can't say that it should be dumped in the dustbin. They shouldn't have brought the application in the first place. It is also always encouraged that people should go to court. We encourage them to go to court to seek redress instead of taking recourse to self-help. Atiku did the right thing by approaching the Supreme Court instead of making careless statements that might ignite riots and protests and bomb Nigeria. he decided to go to court, whatever grievance he has, he assembled a team of lawyers that then assembled out their grievances, issues raised, as per qualification for election, affidavit and qualification, then issue as regards the INEC server, where there was a server, what the results were transmitted. Okay. And all these issues, they were issues they believe that the court should look into and decide. Okay. They are not saying that the court must decide it in their favor, but they believe that these issues ought to be decided by the court, and they went to court.
Okay, Mr. Ajulo, your closing thoughts, please.
Well, let me quickly agree with the fact that when we have election, there's always a way out in which you can ventilate your grievances, and that is why I need to salute the courage of the Alhaji Atiku Abubakar for trying to not taking the laws into his hand or by inciting the public to go out to cause rampage and all that. And that we saluted for that. And that I believe Nigerians should take recourse to that in whatsoever it is, the court is there, the law is there to ensure that any grievances is well met. However, we need to really understand that even in bringing most of these grievances, when you know that you've lost an election, it's always good to accept that I've lost the election. Election going to court should not be another way for you to use as a form of another campaign and trying to raise some sentiment, because this election petition is more sentiment than law. It is so clear there. And that's why I said, I'm not saying it should not be hard, but in some jurisdiction, they don't even allow such kind of frivolous process to even be found into their law court. But this is Nigeria, and we thank our judiciary on that. And that's why I said my party's thought will be to thank and to salute the courage of all those parties, both the lawyers, both the judges, both the petitioners, the parties.
Thank you very much, Mr. Ajulo. I'm afraid we've completely run out of time, and that's where we have to leave it. Mr. Kayode Ajulo, who spoke to us from our studio in Abuja, and Mr. Joe Mokede, both legal practitioners. Thank you very much for coming to look at this with us this morning. Sunrise will return in just a moment with another interesting conversation. Please join us.